Leading off our discussion tonight is Democratic Congressman Adam Schiff of California. He served on the January 6th Select Committee and is currently a candidate for the United States Senate in California. Also with us is Andrew Weissman, former FBI General Counsel and former Chief of the Criminal Division in the Eastern District of New York. Congressman Schiff, so it looks like it's very likely that Mark Pomerantz will end up doing some kind of deposition for Jim Jordan. What are you expecting from it?
Well, I'm not quite sure whether he will refuse to answer all questions or just some questions. But I share the skepticism of this opinion. A judge is really bridle at being described as appointed by this president or appointed by a president of this party because of the suggestion implicit in that their opinions are always going to match who appointed them. But in this case, it is so obviously a judge appointed by a very interested party in this litigation, because it seems like all the presumptions favor Jim Jordan's motivations, and none of them favor Alvin Bragg's. And it also seems to me that the judge here has so buried her head in the sand, unwilling to see what is plainly before our eyes, everything from the hearing, the circus we just had in New York when Jim Jordan brought the committee there to try to embarrass and intimidate the Manhattan District Attorney. But it's not just subpoenaing Pomerantz, it's subpoenaing documents, it's threatening to subpoena the district attorney. Of course, the district attorney is not to blame for Mr. Pomerantz's book. But you have to ignore all of those other plain indicia of the motivation of Jim Jordan. Jim Jordan's heeding President Trump's call, his lawyer's call, to essentially interfere in the Manhattan District Attorney's prosecution. And the capper for me was the one you pointed to, Lawrence, when the judge, in complete Alice in Wonderland fashion, says no one is above the law, while essentially trying to place the former president above the law. So I don't know what happens tomorrow, whether the witness shows up, whether they expect to prevail on appeal, whether they nonetheless show up and answer some or all questions. But I don't think this is the end of the litigation over this.
No. Andrew Weissman, I just want to be so clear about this, that the opinion itself, I don't find the actual opinion itself outrageous. I find it to be just wildly rhetorically out of control on its way to some positions that are defensible, that are legally defensible, and could have been made in a much more modest way and in a shorter opinion. And, if she wanted to be decent about it, an opinion actually written after the lawyer spoke. But you saw this Pomerantz problem coming because your review of this book was by far the wisest thing I read about it, and the potential problems that it could create for Alvin Bragg going forward.
Yeah, so let's start with Mark Pomerantz. In my review, I ended it by saying that if this book improperly hurts an eventual Trump prosecution, one wonders if having this account at this time will have been worth it. And we're seeing that now. When you write a book that is unauthorized without going through pre-publication review, and you do it in the middle of an investigation, you are asking for trouble. And so, that is a fact that was extremely unhelpful to Alvin Bragg in presenting his case. But this is a problem that is squarely on Mark Pomerantz's shoulders in terms of the problem he has created. In terms of the judge, I completely agree with you. I had said beforehand that I thought this was a bit of a jump ball. It was hard to know exactly which way to go because there are very strong legal arguments in favor of the broad discretion of Congress, which I would think, Adam Schiff, of all people, would sort of understand that Congress should have that broad discretion. But there are limits to that. And what's disappointing here is that the judge was so intemperate in her language. She could have gotten to exactly the same place. It's still, this could be appealed on a very narrow legal basis. But to be that intemperate when you're on the bench and in an environment where there are inflamed passions on both sides it's really not becoming for somebody who has an Article III position. And so that I thought was really to say the least, unfortunate. I'm not as worried, by the way, Lawrence, as given this situation that she wrote the opinion beforehand. There's no right to oral argument. And there's nothing wrong, given how speedy the parties wanted her to act, to have a draft ready and then to hear from the parties and then to see if it changes your mind one way or the other. So I really am not disturbed by that. If she had written a more judicious opinion, I don't think we'd be sitting complaining about sort of the timeliness of it. I think it is responsible that she issued the opinion quickly. It remains to be seen. It has been appealed now by Alvin Bragg. I wouldn't count on that appeal being granted, because I really do think that there is a strong argument in favor of the House's legal position, even though I do think she gave short shrift to a number of factors that Alvin Bragg had raised. And then it's going to be for Mark Pomerantz to testify in a deposition. And that really, to me, just on the merits of it, Alvin Bragg, I think, looks really good. I mean, the person who looks bad is Mark Pomerantz. So he may not get hurt that much on the substance.
And Congressman Schiff, look, I, for one, believe that in general, congressional subpoenas should be absolutely responded to. And any issues you have with privilege, invoke them in the question. Invoke them when the question is heard in the hearing. I wish Jim Jordan had done that when he was subpoenaed to testify, something that this judge did not make a rhetorical reach to refer to here. But going forward, the judge made it very clear that Pomerantz is uniquely vulnerable to a subpoena, and no one should think that this kind of same reasoning would apply to being able to get District Attorney Bragg to actually show up and testify to that same committee.
Well, Lawrence, I would certainly agree that a prosecutor should have wide discretion in their investigations, and there shouldn't be too much second guessing of legitimate legislative purpose. That very issue has gone to the Supreme Court, and they have said as much and established a new test for determining whether these kind of efforts to fight subpoenas have any basis and how the courts ought to evaluate them. But as Andrew said, it's not unlimited, and where it is so palpably the case that there is an illegitimate motivation behind the investigation, behind the so-called oversight, where the Congress lacks jurisdiction even to be able to interfere in a local prosecution. These are such extraordinary circumstances, and the claim of legislative purpose is so superficial and false that I don't think a judge needs to blind themselves to it. So I would hope that this decision is reversed on appeal. I would hate to see a precedent where now Congress can interfere in any prosecution throughout the country. If it's someone of their political party or someone in a position of power, they can go to bat for them in this way. That would be a terrible precedent to set. And so I hope the opinion is appealed so that we're not left with this kind of a decision.
Congressman Adam Schiff and Andrew Weissman, thank you both very much for starting off our discussions tonight.
Thank you.
You're welcome. Thank you.